Humans Week presented by Students for Human Life and the Pro-Life Center at the University of St. Thomas School of Law. Quick reminders about what we have coming up this week. First of all, you made the first event, so nice job there. Tomorrow, Students for Human Life Club meeting at 6 o'clock in JRC 126. Wednesday, we have prayer and pasta. It's been a popular event in the past, praying at Planned Parenthood and then dinner at Casetta's after. Thursday, there's a quad demonstration over Convo Hour in the lower quad. Friday, we'll be watching The Human Experience. There will be dinner with that, 7 o'clock in Wolf. And on Saturday, we'll conclude the week with the Spiritual Adoption Retreat. That'll be Saturday morning in the Student Center Hearth Room. So I give you, at this time, Professor Collett, who will talk a little bit more about Roe versus Wade on trial, the event tonight. Thank you.
Good evening, and we are thrilled that you are here. My name is Teresa Collett. I'm a professor of law at the University of St. Thomas. In addition to that, I have served as Special Assistant Attorney General for the states of Oklahoma and for Kansas in defending their abortion laws. Tonight, we've got the co-director of the Pro-Life Center, Professor Michael Paulson, with us. He is going to sit over here because he's my opposing counsel, and we want to sit next to each other so that we can punch each other. No. Yes, there was. So you're fine. No, you're fine. You do. I'm going to talk. I'm going to. Lawyers can do nothing if not talk. All right. So Professor Paulson is actually the presidential chair at the University of St. Thomas School of Law. We were fortunate enough to steal him away from the University of Minnesota. And he has worked in the Office of Legal Counsel and actually done appellate work before the United States Supreme Court, as have I. The third member of our merry band for this evening is Professor Robert Delahunty. Professor Robert Delahunty not only has worked for the Office of Legal Counsel to the President of the United States under several administrations, he also served as Assistant White House Counsel. So the gentlemen that are involved in this endeavor are men who have advised presidents of our nation. And both are deeply committed pro-life advocates. But tonight you're going to see a different side. The Pro-Life Center at the University of St. Thomas is centered in the law school. We're self-funded. We do all of this largely pro bono and through a small number of grants. But part of what we're trying to do is train the next generation of pro-life advocates. Because I believe firmly that I will see Roe versus Wade either wither on the vine or be overturned in my lifetime. And it'll be largely through the efforts of your generation. And so what we're trying to do is equip law students in particular, and undergraduates to a lesser degree, with the intellectual tools to understand why Roe versus Wade was a bad decision from the start and why it simply must either fall into disuse completely or must be directly reversed. So part of what we do at the law school is we teach courses. I teach a course called Constitutional Litigation. In that course, law students will come in and they will begin from the very beginning of the class to represent either the Attorney General of a state that has passed a pro-life law, that will be the role I'm playing tonight, or they will represent the Center for Reproductive Rights. The Center for Reproductive Rights is a public interest law firm based out of New York City who appears in every single case throughout the country, either as amicus or as lawyers for the plaintiff that's attacking pro-life laws. I have never been involved in a case where a pro-life law has been attacked in which the Center for Reproductive Rights lawyers have not shown up either as a friend of the court or as counsel to the plaintiffs. They're a very well-funded law firm run out of New York City that primarily gets their funding from defeating pro-life laws throughout the country. Professor Paulson this evening will be representing the Center for Reproductive Rights. Please remember, none of us share the view of the Center for Reproductive Rights, but part of training a strong pro-life initiative is teaching you the best arguments on the other side and what's wrong with them. Professor Delahunty's job will be to be our inquisitor, the grand inquisitor of this evening. Professor Delahunty has appeared in front of many judges, and so his job is to ask the hard questions of both sides, to make sure that we are capable of answering those difficult questions. We will then suspend the argument at the end of the allotted time period, and Professor Delahunty and Professor Paulson and I will simply comment briefly, but what we really want to do at that point in time is get your opinion. Who won the argument and why? Because if we can't make the argument in front of a friendly crowd, we certainly aren't going to succeed with the argument in front of a crowd composed of the federal judiciary, which is largely no longer on our side. And so as you listen to these arguments, think about how you would rule. This is all done in the backdrop of Roe versus Wade, which is now 43 years old. Roe versus Wade, we have seen an entire generation come of age in which abortion has been available. Our understanding of Roe versus Wade across the panel is that it essentially created an unlimited license to abortion in the United States. A right to abortion that is not limited in time. A right that is unequaled throughout the world except North Korea, China, and 2 other countries. In other words, while it's often a misconception that in the United States, Roe versus Wade only allows a woman to obtain an abortion pre-viability, it is our position that in the companion case of Doe versus Bolton, the United States Supreme Court used such a definition of health that a woman in the United States can avail herself to an abortion throughout the entire 9 months. In the state of Minnesota, we once had a law that said that a woman could not have an abortion after the child became viable. Courts have interpreted that to be approximately 23 or 24 weeks of pregnancy. A federal district court sitting in this state struck down that law, saying that it was vague and ambiguous. So as the law stands in the state of Minnesota right now, a woman can obtain an abortion in the 40th week of pregnancy. That is the state of law. And we believe that it is a product of Doe versus Bolton and Roe versus Wade. What you will hear tonight then is in the backdrop of people struggling for a generation to try to reverse that. And we begin with a very simple proposition, that the law can ban abortions based on the sex of the unborn child, based on the sex of the unborn child at any time throughout pregnancy. I will begin with my opening argument, and then Professor Paulson will follow with his. What I would ask is that you give us a 5-minute sign when I am 10 minutes into my argument. All right. Professor Delahunty, Professor Paulson, do you have any additional comments? Or?
They know I'm the bad guy. And they know I'm not really the bad guy?
They do.
Okay.
They do.
You will believe I'm the bad guy. So are we going to be addressing him as the judge?
We are.
But standing up there?
We are.
Okay. I'm ready.
May it please the court. My name is Teresa Collett, and I represent the Attorney General of the United States. What is at issue today is a federal ban on sex selection abortion. The ban that we propose that is constitutional to this court today is a very simple ban. It simply says that when a woman chooses to end the life of her unborn child based merely on the sex of that child, that abortion will be illegal. It leaves untouched other reasons that women might seek an abortion, and in fact has a therapeutic exception for when there are sex-based characteristics that would give rise to a fetal anomaly. Your Honor, it is the position of this government that such a ban is entirely consistent with Roe versus Wade, Planned Parenthood versus Casey, and this court's most recent jurisprudence dealing with abortion, including Gonzalez versus Carhart. We believe that such a ban is permissible in this instance because the concept of the availability of abortion has always been grounded in the sexual equality of women. While Roe versus Wade itself was perhaps cryptic in its grounding of the constitutional basis in which a right to abortion must be recognized by every state in the Union, we believe the opinion was grounded in the idea that women should have a liberty interest, as this court said in Planned Parenthood versus Casey, in determining when and where their pregnancy should continue. But in this limited instance, Your Honor, because the foundation of sexual equality in this country is at stake, we believe that it is appropriate to ban abortions based merely on the sex of the child.
Counsel, do you accept that this court is governed by the Supreme Court's decision in Casey?
Yes, we do, Your Honor.
And you are proposing not just a regulation of a certain type of abortion, but its absolute prohibition.
That is correct, Your Honor.
And its prohibition throughout pregnancy.
That is correct, Your
But
Honor.
under Casey, we can only permit a state or a government, the federal government, to prohibit pregnancy after the point of viability.
Your Honor, Planned Parenthood versus Casey was a plurality opinion, but has since been accepted by a majority of the United States Supreme Court in Gonzalez versus Carhart. But Gonzalez versus Carhart was very clear that, that a state could ban partial birth abortion in all instances, even though there were partial birth abortions occurring pre-viability.
That's a prohibition on a method of abortion. You are defending a legislative prohibition on all abortions of a certain kind, regardless of method.
That is correct, Your Honor, but the United States Supreme Court has never had the opportunity to assess the constitutionality of a limited ban of abortion based merely on the sex of the child. It is inconceivable that a court that grounds the right to abortion in the necessity of women's liberty in this instance. Oh, I'm sorry. I thought this mic was picking me up. It is inconceivable, Your Honor, that a court which grounds the right to abortion in the concept of women's equality and access to the marketplace would uphold the right of any woman to terminate the life of a child merely because it's a girl. And we know it's happening in this country, Your Honor. The University of San Francisco, one of the primary research institutes advancing the goal of abortion and advancing various techniques of abortion, published a study just this decade in which it found that particularly in second and third children for large immigrant populations, that it was common to engage in sex-selective abortion. In fact,
don't the Supreme Court cases protect, subject to mild state regulation, that does not create an undue burden, the right of a woman in her discretion to have an abortion before viability, at least, for any reason that she chooses?
Your Honor, a limited ban like this has never been to the United States Supreme Court, and we believe because of the unique animus that would be shown toward girl children in particular, that the United States Supreme Court would find, in the words of legal scholar Larry Tribe, a clash of absolutes. There is nothing that is more clear in the United States Constitution post the Civil War era as the equality of all citizens, independent of race, independent of sex. And what is put at issue in this ban is whether or not the government will allow private actions of aggression based merely on the sex of an individual. Your Honor, we believe that it is crystal clear that this sort of limited ban should be acceptable.
Does an unborn fetus have sex?
Yes, Your Honor. In fact, from the moment of conception, there are various biological markers that will tell us whether this child will develop into a boy baby or a girl baby.
That may be, but it's just developmentally a male or a female. It isn't at that moment, the moment, let's say, of conception, a male or a female. It has no sex.
Your Honor, while an embryo or a prezygote may have no identifiable sex, the characteristics are engraved from the moment of fertilization. In fact, as Dr. Jerome Lejeune, a Nobel Prize-winning geneticist, testified before a Tennessee district court, those characteristics are set at fertilization, and they will not vary. They will simply develop and manifest themselves more and more clearly as the gestational development occurs. It is important, Your Honor, to recognize that if the child has no sex, it would be impossible for the abortion to violate the prohibition because there would simply be no evidence that it was a sex-based abortion. However, once the sex of the child begins to manifest itself, or the parties to the abortion become conscious of the sex of that child and make the selection based on a preference for a boy child or a girl child, that is when the law would come into play. We believe that in this instance, the interest of liberty must be subscribed. There are no absolutes in American constitutional law. Even free speech, our most precious of political rights, is subject to reasonable time, place, and manner restrictions. We believe this is a comparable, reasonable restriction that is consistent with the ultimate grounding of the right of abortion in women's liberty
But
interest.
counsel, there are those who argue that unless women have an unfettered right to an abortion, again, at least before viability, they can never fulfill the obligations of full citizenship.
Certainly,
Sexual equality depends, at least for the adult population, sexual equality depends on the availability of abortion.
Certainly, Justices Ginsburg and O'Connor seem to articulate that standard, Your Honor, although it's never been adopted by a majority of the court. It is the position of this administration, however, Your Honor, that quite to the contrary, the availability of abortion injures the ability of women to attain full and equal citizenship. Because what it does is it makes pregnancy a badge of servitude. It suggests that because women are capable of becoming pregnant and experiencing that 9-month period of bringing a new life into the world, that they are somehow inferior, and so we must allow them to become, if you will, Your Honor, little men by eliminating this. That cost, Your Honor, we believe is made at women's authentic freedom. This country has not progressed from its time in pre-Roe versus Wade, in which we had our first women justices on the state Supreme Courts. We had our first women U.S. senators. We had our first director of the New York Stock Exchange that was a woman. We had our first woman ambassador, and we had our first candidate for president of a major political party. All of that transpired before Roe versus Wade, Your Honor, and in the very year that the court held that the right to abortion was necessary for women, in 1973, the Department of Labor Statistics opined that women who had college degrees had the same economic opportunity in this country that men of comparable educational status had. Roe versus Wade has done nothing to advance that, Your Honor. In fact, Roe versus Wade has retarded that progress, as we see with the continuing wage gap. And why is that, Your Honor? It's because this idea that women have a problem that must be solved through abortion, instead of recognizing that pregnancy is a natural and viable aspect of the life cycle of the vast majority of women in this country, and that commerce and the marketplace of ideas and the public square should accommodate the reality of women instead of punishing them for that reality.
We're not sitting here to overturn Roe versus Wade. Right?
Your Honor, this court doesn't have the authority to overturn Roe versus Wade, nor is it the position of the government at this time that such an overturning would be necessary, although this administration would welcome the overturning of Roe versus Wade.
We're only asked to uphold a law that excludes one motive or reason for having an abortion.
That is correct.
Otherwise, it would be constitutionally protected.
That is correct, Your Honor, because
how can this law be enforced? How can we, without deep intrusions into privacy, and perhaps not even then, discover whether a woman's true motive in wanting an abortion is because she dislikes the prospect of bearing a female child?
Your Honor, at this point in time, what is crystal clear is that a number of states require the reporting of a woman's self-identified motivation for obtaining an abortion. Under this law, excuse me, a physician who learns that a woman's primary motivation, sole motivation, is to abort a child simply because it is a boy child or a girl child will, in fact, in that instance, Your Honor, this law is fully enforceable because even at this point in time, many states request the reporting of women's motivation in obtaining abortions. And once a physician learns that a woman's motivation in obtaining the abortion is to eliminate a boy child or a girl child because of the sex of that child, the physician will then know that they are under a legal responsibility to abstain from performing the abortion. If they go forward, Your Honor, and if there is adequate evidence that they had that knowledge, then the prosecution can ensue.
But this law strikes me as an inducement to both the woman and the doctor to lie. As women learn that they may not be able to obtain abortions if they specify that the motive for the abortion they want is the sex of the child they're carrying, they will dissemble. Likewise, doctors to whom women truthfully report that their motive is to eliminate a female unborn child, the doctors will deny that that was ever reported to them. This is a law that encourages criminality, it strikes me.
Your Honor, that same argument could be made against Title VII or any number of the civil rights legislation that is on the books and has been successfully enforced since the 1960s in this country. The simple fact is that people do often give a candid answer to that question. And where the record establishes that that was the motivation, then prosecution will be impossible. We should also not disregard the very important teaching point of this law, Your Honor, that sex cannot be the basis for the elimination of the life of the unborn child. That in that instance, there is a clash between the equality of all citizens and their right to government protection of their lives and the right of the woman to be free from an unwanted pregnancy. We believe that balance in this particular instance, Your Honor, will lie with the state's enforcement power. The United States Supreme Court, in its most recent fulsome opinion in this area, Gonzalez versus Carhart, in reviewing the partial birth abortion ban that was passed by the federal government, opined that in fact we had for too long underestimated the state's interest in protecting human life. Justice Kennedy.
What gives Congress the power to enact this statute?
Your Honor, because abortion is a commercial enterprise and because it transcends states' borders, there is in fact a commerce power within that. It also, Your Honor, can be found within the general powers of Congress to promote the common welfare, particularly in this instance. Finally, Your Honor, we would argue that the 14th Amendment's prohibition of sex-based discrimination gives it the power to enforce such a law. Your Honor, it is the opinion of the Attorney General of this country, at whom I represent at this point in time, that abortion has for too long been unlimited in this country. No reason, no time limit, no constitutional limits allowed to the states. That, Your Honors, we believe is not grounded in the text of the Constitution, not grounded in the history of the Constitution, and is not grounded in the necessity of liberty among a free and equal people. This particular law may well be an intention to be the edge of the wedge. But in that instance, Your Honor, and I do concede, as I see opposing counsel, that that may well be the intention, but that is not something that renders it unconstitutional. There are many things, Your Honor, that while we cannot forbid, such as blasphemy perhaps, such as racial epithets, that in a free society we cannot forbid, we can certainly regulate. And in this instance, where there is a compelling state interest in ensure the equality of all citizens before the law, to ensure equal protection of their very lives before the law, this law must stand, and Roe must give way. Thank you, Your Honor.
Your Honor, may it please the court, my name is Michael Stokes Paulson, and I represent the plaintiff and respondent in this case, Dr. Leroy Carhart. Your Honor, this is a case about privacy and freedom of choice. The fundamental question in this case is not about abortion per se. It is about who gets to make the very difficult and personal, fundamentally personal decision about whether to bear or beget a child. Now, Your Honor, we will in this presentation make four broad points. Okay. First, that there is a fundamental constitutional right to privacy, which includes, as the Supreme Court has held, the right to choose whether to terminate a pregnancy by abortion under Roe versus Wade. Secondly, we will argue that the human fetus is not a person within the meaning of the Constitution, but only potential human life. The state's legitimate interest in such potential life arises only at the point of fetal viability and not before, and even then must yield to such considerations of the pregnant woman's life and health. There's a delicate balance, and Roe versus Wade strikes that balance. Our third broad point will be that the principle of stare decisis and respect for precedent requires even the Supreme Court to adhere to its prior decisions in Roe versus Wade and in Planned Parenthood versus Casey. The courts cannot go backwards and reverse such a fundamental constitutional right. And for lower courts in particular, there is no discretion to do so. And that will bring us to our fourth and most salient point with respect specifically to this statute. and that is that a statute that bans a reason for abortion, that bans a reason why the choice is exercised, is simply not permitted under the Supreme Court's decisions in Roe versus Wade and Planned Parenthood versus Casey, because it imposes a quote-unquote substantial burden, and that's the Supreme Court's language, on a woman's freedom of choice by banning a particular reason for abortion. Your Honor, I will address your questions, but otherwise I would just like to hit each of these points in more detail. Okay. First of all, there is a fundamental constitutional right to privacy, and that right to privacy includes the abortion decision. Before Roe versus Wade, the Supreme Court in Griswold versus Connecticut, an Eisenstadt case, had upheld that there is a constitutional right to contraception and characterized that right in terms of the freedom of the individual to make the choice whether to bear or beget a child. Bear or beget a child. That logically led to the Supreme Court's decision in 1973 in Roe versus Wade, establishing a constitutional right to privacy that included the choice whether or not to go forward with a pregnancy once it was begun. Surely, Your Honor, we submit that the government could not forbid pregnancy. It could not require abortion. And if the government could not legally mandate abortion, it seems to follow that the right to choose must adhere in the Constitution, that the individual has the right to make that decision. And it is simply unthinkable that the government could mandate abortion. So really what it comes down to is that the right to choose whether to bear or beget a child must reside within the decision of the woman who is in the pregnancy situation.
Counsel,
yes, Your
Honor. In Roe, right at the start, the court distinguishes between the claim that the woman has an absolute right to an abortion and the claim that she has a fundamental right. And it concludes that she has a fundamental right but not an absolute right. It strikes me that you're arguing that the woman has an absolute right to an abortion, no matter how compelling the government's purposes may be for denying her an abortion in some circumstances. Isn't the correct standard of review in this case strict scrutiny? And shouldn't you be addressing the questions whether the government has a compelling purpose in banning sex-based discrimination in abortion?
Your Honor, certainly the court in Roe versus Wade attempted to craft a balance, but that balance is one that puts a strong thumb on the scale on the side of individual privacy and choice. The court's decision in Roe versus Wade establishes that to the point of viability, the decision whether to terminate a pregnancy is the woman's alone in connection with her doctor. You can characterize that as absolute or fundamental, and in part those are just legal weasel words. It is clear that up to the point where the child could live outside the womb, the woman has the right to choose based upon whatever factors the woman and her doctor feel most appropriate, whether to go forward.
Are you contending that this federal law is unconstitutional even after the point of viability is reached?
Well, I think we can break it down between pre-viability and post-viability, and I think in the end the outcome is the same. Let me explain why. Okay. Pre-viability, it is clear under Roe versus Wade and Planned Parenthood versus Casey that the choice must be as to whether or not to have an abortion must lie with the pregnant woman. That is a choice, and that choice can be exercised under the Supreme Court's decisions for any reason. Now, the state, the government in this case, has come up with an ostensibly persuasive reason for banning abortion. But notice certain flaws in that, okay? First of all, once you interfere with the reasoning process, you've opened up a slippery slope in which the government can intrude upon the privacy of the decision-making process and decide, well, this is a good enough reason, that's not a good enough reason. And pretty soon you have this situation of the government essentially taking away the autonomy and the freedom of choice. In addition, as Your Honor pointed out, I think very insightfully, it's kind of a ruse, right? You know, saying, oh, you can't have abortion for this particular reason. Well, as soon as anybody with half a brain understands what's going on, they will check a different box. I think it is theoretically possible that some women might be motivated by the gender of the child, but I think that that is not the real thing that the government is trying to accomplish here. It is, in a telling revelatory statement by opposing counsel, this is the edge of the wedge. The idea here is to interfere with freedom of choice. It makes no logical sense, Your Honors, we submit. It makes no logical sense to say that abortion is a constitutional right if had for some particular reason, but is a legal wrong if you have the wrong purpose in mind. It is antithetical to the whole structure of Roe versus Wade and Planned Parenthood versus Casey, which contemplates that the government does not interfere with the choice. It is for the woman and her doctor and other members of her family with whom she decides to consult.
So if a woman decides to have an abortion so that she can sell the tissue of the slain fetus to Coca-Cola so that it can test with that genetic material how satisfying to our taste buds a new Coke product will be, the state cannot ban that, at least if the abortion occurs before viability.
Your Honor, as lurid as that hypothetical situation sounds.
It's not hypothetical, actually.
As lurid as that sounds, whether hypothetical or not, the premise of Roe versus Wade and the court's subsequent decisions reaffirming it is that the decision to abort or not abort is for the woman's choice, period, full stop. Her reasons for doing so, her motivations for doing so, are legally irrelevant.
Let me try another hypothetical.
I'll answer them all the same way.
Okay, let me try it. We discovered that there is, in fact, a gay gene. Lots of pregnant women are tested to see if their fetuses are carrying the gay gene. 99% of the women who discover that they are have abortions, and this results in an additional 80,000 abortions a year. The government can't intervene to prevent that.
The right to choose whether or not to have an abortion is constitutionally a matter of the private decisional choice of the woman. Your Honor, I think if you and I were just having a conversation and a beer and discussing what strikes us as good reasons and bad reasons for abortions, we might agree on a lot of things. We might draw the lines in some different places. But the entire premise of Roe versus Wade and Planned Parenthood versus Casey is that the government doesn't get to draw the line. Now, we might think that some lines would be good lines, but that's not what the Supreme Court said. The Supreme Court says prior to the point of viability, it is absolutely the decision and choice of the woman involved. And Roe is fundamentally a decision about who gets to make the decision. Okay? We may disagree on some of these things, but the premise is this is the woman's body. This is her medical condition. This is her situation. And consequently, it is her privacy right and her autonomy right. And further, as reinforced by the Supreme Court's decisions in Planned Parenthood versus Casey, this is not merely a matter of privacy and autonomy, but it is fundamental to women's equality. Now, I know the government tries to make this point, but what if they use this right of abortion to abort primarily female fetuses? The focus should be on the autonomy and the right to equality of the woman. Men do not become pregnant, not in my experience, not in your experience. Abortion restrictions are targeted at, in a sense, whether intentionally or not, and impact most directly women. As a matter of fundamental equality of the sexes, that means that women who are in a situation of pregnancy must have the equal rights that come with the ability to choose whether or not to carry that pregnancy to term. Finally, Your Honor, I think I have a few minutes left, right? I get full 15. Okay. Finally, Your Honor, you in the position of a lower court, with all due respect, do not have the discretion to ignore Roe versus Wade or Planned Parenthood versus Casey. The Supreme Court's decisions are binding on the lower courts, and I think it is absolutely clear that, like it or not, Roe and Casey establish that the right to abortion may be exercised for any reason that the woman chooses. The sole question is whether a law puts an undue burden on the woman's choice.
The undue burden test only applies pre-viability. I still am not
Yes.
sure whether you would agree that this statute could be constitutional as applied to abortions in the third trimester, abortions more generally after viability.
I would like to address that. The third trimester, the point of viability, and people differ as to exactly when that point occurs, presents a slightly different legal analysis. I think it is more difficult. I think the analysis as to pre-viability, when the unborn fetus could not live outside the womb, is absolutely clear. Even for post-viability situations, the court's decisions have been clear that abortion must remain the right of the woman for reasons of the woman's life or health. Now, health is used by the Supreme Court's decision, is kind of a term of art. It's not the common understanding of health. Health, as incorporated by the Doe versus Bolton case, makes clear that the woman's health considerations, the reasons she may have an abortion on health grounds, include such considerations as emotional well-being, psychological well-being, as well as physical health.
So we have to assume that women who put down baby girls in the 9th month of pregnancy are doing it because their own health is at stake?
Health in the sense of they may have emotional or psychological or, and this is another term that the court builds into its definition of health, family considerations. Now, you and I, again, we might agree that this is not a sufficient justification for an abortion, but imagine the situation where a family has had only children of one sex and sincerely desires a child of another sex. For cultural reasons, this might be extremely emotionally or psychologically upsetting. Under the Supreme Court's decisions, that falls within the rubric of health justifications for abortion. Now, frankly, Your Honor, I don't think that people very commonly, if at all, and there's no evidence in the record supporting that this actually happens, by the time of the 7th, 8th, or 9th month of pregnancy, make abortion decisions on the basis of sex selection. Sex can be determined, as counsel for the government conceded, very early, at various early stages in pregnancy.
Can be, but it's not always.
Not
Sometimes,
always.
one reads in reliable periodicals like the New York Times, for example.
What's that?
Quite a few pregnant women don't discover that they are pregnant until sometime in the 3rd trimester.
There may be exceptional circumstances, Your Honor, but we're not dealing here with a specific case of exceptional circumstance or an as applied. We're dealing with a broad law that forbids throughout all stages of pregnancy a particular reason for having an abortion. Once you go down that path, the slippery slope is fast to the bottom. Okay, the government can say, well, this is not a good enough reason. This is not a good enough reason. Oh, we don't like this reason either. And once you go down that path, you are pretty quickly to the point where the government can decide for you when and when not you must have a baby. That is flatly inconsistent with Roe versus Wade and Planned Parenthood versus Casey. I would acknowledge that the analysis is a little more roundabout at the stage of viability. If this court were to, as it were, split the decision in two, it is absolutely an easy case, a lay-down case, that a ban on sex selection abortion pre-viability is unconstitutional. This court would have to hold, in contravention and kind of violation of the Supreme Court's precedents, that health does not include family considerations that the woman and the doctor think are sufficiently important to a woman's psychological well-being, that is not a sufficient health justification. I understand the court's inclination to do that, but this court should recognize that it would be acting in clear violation of Supreme Court precedents. Your Honor, when the Supreme Court speaks, we don't always agree with the decisions, right? We don't always agree with what the Supreme Court has held. But that establishes what the Constitution means, and that is binding on lower courts and on all officials, government officials at every level, and on all good citizens. We must adhere to the decisions the Supreme Court has made and go forward with them regardless of our policy disagreements with them, because the Supreme Court's very supremacy establishes that they are the authoritative interpreters of the Constitution. Obviously, it's a duty incumbent on lower courts to follow what the Supreme Court has said. Your Honor, in conclusion, if I may, ultimately the issue comes down to who gets to make the choice. We may agree with some of the choices made, we may disagree with some of the choices made, but the question for abortion is not about the morality of the particular abortion in a given case. The government has no authority to prescribe morality for us for morality's sake. The question is who gets to make the difficult, often gut-wrenching, moral decision as to whether or not to have an abortion. Roe versus Wade and Planned Parenthood versus Casey establish beyond any doubt that that decision must lie within the private, autonomous choice of the woman. Thank you. If this court has no further questions, I will sit down.
Your Honor, if the United States Supreme Court precedent had ended with Planned Parenthood versus Casey, perhaps this law would have never been passed by Congress. But it didn't end there. In fact, the United States Supreme Court, in looking at the federal ban on partial birth abortion, said, for too long, we have underestimated the legitimate state interests that affect even pre-viability bans. Opposing counsel has suggested that any limit upon intentions will eviscerate the right. And while there are many Americans who would hope that to be true, that is not the way the law works. A comparable area involving the value of human life, of course, is at the end of life. And the United States Supreme Court, in its case of Vaco versus Quill, and in the Glucksberg opinion, Washington versus Glucksberg, looked at could there be a ban on physician-assisted suicide in the state of Washington and in the states of New York. In that instance, the court said that while there are many activities that physicians could engage in that might actually hasten the death of a patient who's suffering from cancer or some other terminal disease, that it was the intent that would govern whether or not it was criminal activity, and they upheld the constitutionality of those laws, Your Honor. In this instance, what Congress has attempted to do is a very limited prohibition of abortions on the basis of the sex of the unborn child. That very limited prohibition, in fact, goes to the ostensible interest in maintaining the right to abortion, the right of free and equal citizens to be treated as equal, independent of their sex.
Counsel, you are right to say that the Supreme Court, both in Casey and later, has recognized that the government has legitimate interests in fetal life throughout pregnancy, from the very beginning. But the Supreme Court to date has identified really only three interests altogether, whether of the fetus or of the pregnant woman, that might underpin justifiable state intervention. The life and health of the fetus, the life and health of the mother, and the mother's ability to give an informed consent. Nowhere has the Supreme Court stated or implied that the government has an interest in protecting fetal life from discriminatory bias.
But, Your Honor, the question has never been presented to the court in this manner. And we believe that this court would not be exceeding its jurisdictional limits as a trial court in finding that because it is a unique question, a question that's never been presented to the United States Supreme Court, that the compelling state interest in defending against sexual animus, a distrust of the female sex in this case, a desire for only boy children or only girl children, that in itself is a compelling state interest and that warrants this. Your Honor.
Can the government properly, constitutionally, intervene in adoption decisions where the adopting couple prefers to have a boy rather than a girl?
Your Honor, there's, to my knowledge, never been any evidence of such a practice, nor has the government attempted to. But in this instance, there have been scholarly studies in the United States that have found that certain immigrant populations do indeed engage in sex-based abortion. We need only look at the studies done by the American Society of Reproductive Medicine that's looking at preconception or pre-implantation selection of embryos to see that there, in fact, is a strong bias toward what opposing counsel called family composition or family balancing. The American Society of Reproductive Medicine initially took the position that it was perfectly legitimate for couples to prefer boy children over girl children, but only after public outrage was expressed against the society did they change their official position about this family balancing. Let me deal with the health exception as opposing counsel has defined it. While it is true in Doe versus Bolton, the court was interpreting a Georgia statute at issue about whether or not a second opinion could be required for an abortion at a time in which abortion was largely illegal throughout the United States. And in that instance, as a matter of statutory interpretation, they determined that family composition, economic situation, emotional health of the woman were all relevant under the Georgia statute. But a more limited exception was contained in the Pennsylvania statute that came before the United States Supreme Court in Planned Parenthood versus Casey. In that instance, the state of Pennsylvania had limited health to those instances where it would result either in the death of the woman or a substantial impairment of a major bodily function, eliminating the family composition consideration, eliminating the economic consideration. And in that instance, the United States Supreme Court upheld that definition. Therefore, we believe the definition in this statute that allows the sort of professional discretion where there could be some sex-based characteristic that may in fact imperil the health or well-being of the woman or the fetus. Eliminating prosecution in that case is an adequate defense. Your Honor, in this instance, you have a unique opportunity to stand with all women, not just those women who choose abortion, to stand for sexual equality in this limited instance and uphold this law as constitutional. The United States Supreme Court, Justice Kennedy writing the opinion in Gonzalez versus Carhart, has shown this court the way. Pre-viability bans in and of themselves are not unconstitutional, and under these limited circumstances where we have a compelling state interest that is protected by a narrowly drafted law that limits the prohibition only to those instances where it is the sex of the child that is the motivation behind the abortion. In that limited instance, Your Honor, the constitutional mandate for sexual equality must prevail and must trump. Whether that leads, as opposing counsel suggests, down the slippery slope toward a far more limited right to abortion, only time can tell. But that is not the decision before this court today. The decision before this court today is whether or not children can be eliminated simply because of their sex, or whether the congressional powers to eliminate discrimination in this country continues to impact even those children within the womb. This government argues that, in fact, again, Gonzalez versus Carhart shows the way. This court need only merely craft its opinion to follow the path that Justice Kennedy laid in his majority opinion and uphold this very limited statute. Thank you, Your Honor. So how would you rule?
As a district judge?
Mm-hmm.
Well, I think I'd rule your way. Damn it, be overruled.
Good for you.
You're asking how I would rule.
Yes.
Maybe the better question is, how do I think most district courts would rule?
And I'm sure our mic lady is going to come back and say, please hold the
How
mic.
do I think most
Yes.
district courts would rule? I think they'd rule either against you or they'd split the loaf.
And give me post-viability, but not
Yes.
pre. Mike?
I think that's right too. As I hope you've been advised, I don't believe a word of what I said. Well, except the actual descriptions of the Supreme Court's decisions and what the precedents entail. I actually do believe that, but I find none of the arguments actually made persuasive. This is an issue I've been involved in, worked with committee staff in the House of Representatives, for a number of years now on trying to get a bill banning sex selection abortion to the floor and in front of the president, which he would clearly veto. In part because I think it is such a persuasive way of thinking about the abortion issue. right? In fact, if you're so inclined, I have some online articles addressing this. You'll remember the title. It's called "It's a Girl," right? Because the idea is the fact that the fetus has a sex, has a gender, and that abortions are happening based upon sex determinations shows that it's not just an it, right? And that's the ideology of the pro-choice or pro-abortion movement. You know, it is a girl or it is a boy. And I think that really has a lot of resonance even with pro-choice people. If you ask your pro-choice friends, you know, what do you think of sex selection abortion? They'll recoil a little bit. And it's good to sort of explore that. Actually, I think as a matter of legal doctrine that under the Supreme Court's decisions, banning sex selection abortion would be unconstitutional. Unconstitutional under the Supreme Court's decisions. But that, I think, provides the most persuasive context for bringing a direct challenge to Roe versus Wade because, my gosh, really, can it mean that? And I think you might get some lower court judges to say, oh, no, forget that. I'm not going to follow the Supreme Court all the way over the cliff on this. Sex selection abortion, it makes no sense whatsoever. And I think most likely they would say, well, I know they've said these things about what counts as a health justification for abortion, but oh, come on. You know, abortion for reasons of sex selection of born children, how do you really get that out of health? Yeah, I know they've said that before, but I would actually bet the Supreme Court, if you got this issue to them, well, I'm not really sure what they would do. Part of me thinks that they would say, oh, we didn't mean that. And they'd say, no, you can't, you can ban sex selection abortion, that's just awful. Which I would love because it sort of puts them in conflict with their own premises. But another part of me worries that they would say, hey, choice is choice. You know, we don't interfere with it. And that actually might be a desirable result too, because it would expose the Supreme Court as really a totally lawless and renegade institution, and it might actually lead to people rising up against decisions of that sort.
My prediction is based on the fact that when you actually look at the cases, the United States Supreme Court has never struck down a federal law regulating abortion. Never. If we can get it through Congress, the court upholds it. They've only struck down state statutes. And so if it actually were the congressional act that I believe made it out of the committee and out of the House last time, didn't it?
Well, what happened is, gosh, this is highly technical, and someone who's had
boring.
An internship with Congress might understand it, because I don't even understand it. It got to the floor and received a majority vote, but it came to the floor under a special rule that sort of bypassed usual procedures, and so it required like a 2/3 or a 3/5 vote, and it didn't have that. So there was a majority for this, but it did not get forwarded to the Senate.
Okay.
That was in, I think it was May 2012.
Right, 2 years ago.
Right.
And so this is not a pipe dream. This is a real possibility, depending on the composition of the two chambers, that we could actually pass this law. And the reason we used it as the example is because it really is intended by many to be the edge of the wedge, as I described it, because right now the court, as Mike accurately argued, has sort of taken the position that anything pre-viability has to be okay, except for a particular technique. And Professor Delahunty called me on that and said, well, wait a minute, the partial birth abortion ban didn't limit the number of abortions, it just said you have to do them a different way. You could still get one, you just can't do it that way. You've got to use a different procedure. And that's right. The final point, so this hypothetical that we're arguing isn't all that hypothetical. There is legislation in Congress, a majority of the members of the House voted in favor of it, but because of this procedural anomaly, it didn't make it to the Senate for a vote. And frankly, that wouldn't have mattered because the current president would have vetoed it anyway, and it certainly wouldn't have the numbers to be veto-proof out of both chambers. But it shows you the sort of strategy, which is part of the educational purpose of tonight, is when we see these laws, whether they're 20-week bans or they're sex selection bans or they're ultrasound requirements or there are any number of these other things that seem like partial measures, it's part of a strategy to get back in front of the United States Supreme Court and give them a set of facts that will compel them to rethink the premises. And I agree with Mike. I think this is actually, no pun intended, the most viable prospect we have of getting the court to actually give us something that says a person's a person no matter how small. The problem with, exactly, the problem with the 20-week bans is I'm afraid that we are simply collapsing in on ourselves, and when we hit 12 weeks, that we will lose the political motivation to protect, and 80% of the abortions in this country happen in the first 12 weeks. Now, every life we save is important, every life we save is precious. So this is not so who cares about the 180,000 children in this country that are aborted after 23 weeks, post-viability? 180,000 every year in this country. Who cares about them? I care a lot about them. But I'd rather save 1.3 million if I were given the choice. And so that's why I think Mike's right to go toward this. Let's open it at this point then to questions, comments. How would you have ruled, not knowing the law? What do you think, lady in red?
I guess in the, looking at the two arguments that was presented, I think I would have ruled with you mainly because of when he brought up the second hypothetical of if there was a gene for being able to test for gay, and then 99% of the people that were then choose to be aborted, and then the response to that, it was the thing that went instantaneously in my mind was if we're gonna be able to say no, we can't prevent people from picking out and stopping something and what went through my mind was genocide. If that was allowed, that you could abort people based on a gene, then that's basically saying what prevents someone from aborting someone because they have blonde hair or blue eyes or anything like that. So then it's just becoming more of a genocide thing than anything else.
Okay.
Can I ask a question? Because I'm really trying to gauge, what would be persuasive to people. Do you have the same sort of concerns, genocide concerns, for what might be called gendercide? Right? Does sex selection rile you the same way as other physical character? I mean, blonde hair. I think blonde hair is great. Don't you? Right.
I pay every 3 months for it.
But-
yes.
But the reality is, since I think it was 1991, an economist did a study. Okay, a Harvard economist named Amartya Sen. Okay, who was able to statistically identify based upon differential birth rates throughout the world. Okay, because there's nature has an equalizing birth rate. It's approximately 104 males to 100 females, because more males die off young or die
For
in
their
war.
own aggression.
Right. But they were able to, to compute statistically that in some areas of the world, the ratio was more like 140 to 100. Okay? And if you project that out, this economist was able to determine in 1991 that there are 100 million girls missing. That somewhere along the line, statistically, they were culled out of the population, either through infanticide or through sex selection abortion. That number is now, by most calculations, somewhere in the area of 164 million women, girls, that have been killed for being girls. Do you find that persuasive?
Yeah. We had a question here, the young lady in the t-shirt. The heart, the big heart.
Yeah. I said what I would rule on this. That's what I'd like to share. I might have ruled with you, Professor Collett, but I'm afraid I'm going with Paulson. Yes, because
I don't want to win.
well, you had indicated in your argument that it wasn't the edge of the wedge, and that's not how the law worked. And you reversed what you said after the argument, and the fact that that was the real motive behind it was kind of disturbing because I'm a strong feminist,
So am I.
and I believe in pro-choice. So I found it difficult to see that your motive behind this was really to open up the gate and let this all open up to all sorts of reasons not to have abortion.
So let me give you the best argument in response to that I also believe, which is that laws collapse under being extreme. And I think to rule against this law will illustrate how extreme the abortion license in this country is. And so my concern is that the really smart pro-choicers are going to stand with us on this because they think it's so rare and so hard to prove in order to defend the wall on other bases like we've got to make sure it's available for women who are economically coerced. We've got to make sure it's available for women whose husbands have walked out on them. We've got to make sure it's available for the circumstances where all of us, including Blessed John Paul, have deep sympathy for the motivations, the tragic circumstances. That doesn't mean we justify their behavior. It does mean that we see that these are difficult and hard circumstances. So I'm not so sure that that gets you where you want to go.
And I do agree with your initial argument. It was just the fact that you had said something that contradicted it afterwards that was bothering me.
Can I ask a question about the question? Why should it matter what the motive of people for pass the law is if you think the law itself is right and constitutional? You know, if you agree with me on something, but distrust my motives, because I'm a very untrustworthy guy, but you agree with me on this point, are you led to disagree when you would otherwise agree because you don't like the motives of the person that you agree with? I wonder about that.
If I knew your intentions like I had, that would change my decision, yes.
Why? I mean, I'm genuinely curious.
It sounded, reversing what you said after the argument, it sounded almost corrupt to me. It was in a way lying, you know, putting up a false front to get what you want. And I didn't agree with that.
Mm-hmm. Okay, just want to understand.
This is a question that comes up in the Supreme Court all the time, right? And my very favorite quote on it, and Justice Scalia is not my favorite justice, although I'm fond of him. But my very favorite quote comes from Justice Scalia when he says, trying to figure out legislative intent is like looking out among a crowd and picking only your friends, right? So you've got 100 senators, all of whom will vote for different reasons. I will tell you, having lobbied at the state and at the federal level, at the state level, I have had legislators say to me, Teresa, I would vote for parents to have the right to know if their child was getting an abortion, except my husband, my wife will not let me come home tonight if I do that. Okay? Now, what kind of legislative motive is that, right? But my answer to that, because practically I'm not going to win over his wife, right? Nor should I. But my answer to that is, could you at least go get a cup of coffee during the vote? If you can't vote for me, can you just not make the vote? And so I think it's really hard to know what legislative intent is. Mm-hmm. I know I've drafted bills that people have voted for the most bizarre reasons that, you know, because they're voting for bills that I've drafted. I'm sort of a fan, but it's like, really? That's why you're voting for it? Okay. So, yes, sir.
Hi, my name is Jonathan Leipsch. I argued this issue before most of you were born. I was a sophomore in college, and I argued this with a co-ed at a political caucus meeting. And it was just 4 months later that Roe v. Wade happened. So that was 41 years ago.
1973.
And ever since then, I've been looking for ways to persuade people that it is a person, and there are states making inroads now defining personhood, and that's helping to change people's minds to recognize that it is a person. And I've got a picture from personal experience that says more than 1,000 words, and I'll show it to you now. Ever since I got married, I had thought how wonderful it would be to be able to show a person, a baby in the womb, the same baby in the womb, and then after it was born. And my daughter-in-law graciously allowed me to use her ultrasound picture. So this is my first grandson, Andrew, and he was 130 days old in the womb there, and this is 37 days, 37 days after he was born. And so for me, this is proof, mathematical, if you will. This is his arm here, and the same profile. Same person now. He's 3 years old now. It's the same person here, same person here. Yes, it is a baby. It is a person. And that's the means by which I think we should argue, since it's in the Constitution. So it goes beyond just a state's issue, because our Constitution uses the word person all throughout it. And one of the things it says is, you shall not, no person shall be deprived of life without due process.
Thank you. Some year, if you really want to pick a fight, you should have us talk about pictures, because I confess when he brought it forward, I was going, I may have to stop him. But I think that's one of the interesting things. Professor Deevil? Oh.
Could you talk just quickly about wrongful birth lawsuits?
Sure. Wrongful birth lawsuits are premised upon a doctor's failure to diagnose accurately some sort of anomaly within the womb. And so the 99% statistic, of course, was, I think, an indirect reference to the practice that's occurring with Down syndrome. If you can diagnose a child having certain non-lethal anomalies, lethal anomalies are where perhaps there is some structural defect that will cause the child to die very quickly after birth. Some people will talk about, for example, anencephaly, not hydrocephaly, where there's water on the brain, which actually is just the most amazing thing now. You can go surgically into the womb and put a little shunt, and the water drains out and the brain develops naturally, and it's a wonderful blessing of living in this day and age. Anencephaly is where the brain simply doesn't develop, and there's an open skull often that accompanies it. And the child most typically will die within 72 hours of birth. Wrongful life cases don't really come to those cases. Where they come is the case where the baby has some sort of limitation like Down syndrome that could be easily diagnosed. And the parents are of such despair that this child is so difficult to raise that they sue the doctor saying, if you had only diagnosed this child in the womb during the period in which abortion was legal, remember in Minnesota it's illegal the entire 40 weeks, if you'd only diagnosed this at a point when abortion was legal, we would have chosen to abort this child rather than bring it into the world. And so what you owe us, doctor, for your negligence, for your failure to properly identify this defect, is you owe us the cost of raising a handicapped child versus the cost of raising a healthy child to adulthood. States are divided on whether or not such causes of action should be recognized. And a large number of states actually have statutorily said that the birth of a child can never be a wrong, and that they will not allow the family to recover. But the argument, of course, on the other side is that it's difficult. It is more difficult. There are child care responsibilities that accompany a child that has special needs. And so there are states in which doctors can be legally liable for failure to diagnose and provide the opportunity of abortion. One of the defenses that's common, though, is for the Physicians' Council to suggest that if the family did not want the duty of raising that child, that there are options available to them, like the Baby Moses laws that are prevalent throughout the United States, where a parent, a mother who does not want to raise a child, need only leave that child at the hospital, and there will be no pursuit. The child will then be made available for adoption, and the woman is free of all parenting responsibilities. So there are various defenses, but there are jurisdictions where they can recover for failure to advise the woman about the abortion.
The reason I'm asking is that typically, if I understand the parent's statements in court, the claim is that they would have aborted the child because of disability.
That's correct.
Okay, so disability would then be much like the sex selection question, right? You would be saying, I'm aborting this child because of the sex, or I would have aborted this child because the child is disabled. How do disability laws or folks who wish to be activists for disability laws, how does that play out?
For next year, I would suggest that you have my colleague, our colleague, Professor Lisa Schultz, come and talk. She's an expert in this area. She's absolutely wonderful. She and her husband are, in fact, the parents of a child with Down syndrome and have done a remarkable job with Petey. But that has been one of the challenges that she has posed to the disability community, is how can we at the same time go and demand that the state assist us with special needs children, special educational programs, supplemental income for their medical needs, et cetera. How can we demand that and at the same time say, but we've got to make sure abortion is available so that these children never come into the world in the first place? And she has a very compelling personal testimony, a wonderful legal argument, and she's making some progress. But overall, the disability community has not embraced the pro-life position. Yes, ma'am.
Okay. I have like two little things. First of all, in the specific strategies that are used to test the sex of a child, I know you mentioned that like you can tell by the zygote period of the zygote at the time, right? But a lot of those strategies that are used are quite invasive, and they actually endanger the child. So I was wondering how you reconcile endangering the child in the womb just to find out the sex of the child, rather.
Oh, I don't.
Okay. Okay.
They shouldn't.
They shouldn't.
We're done.
Go and figure out. Okay. Okay. Sounds good. Okay, perfect. Okay, and then that's nice. Or what about from the other perspective? Can you pretend a little more? Would that be okay?
Counsel?
Well, usually the argument works the other way, right? That the couple seeking the option to abort, or the woman seeking the option to abort, wants to know the gender or sex of the child in order to make the decision. So it's someone who is contemplating the possibility of abortion anyway, and so, amniocentesis.
Embryonic sampling.
Amniocentesis, I believe, is now reasonably safe, but poses some slight risk of a problem. Because it involves an injection in order to withdraw amniotic fluid from which you can discern gender. Now, with the advent of ultrasounds, pictures, right? You can know at a fairly early stage just by looking for stuff, you know, whether it's a baby boy or a baby girl. And the reality in many Asian countries is that this is incredibly cheap, non-invasive, right? And people will do it in India and China out of cars. You know, come to our car, I have a little machine, we'll take the picture, oh, it's the wrong sex. And then there's the surgical abortion procedure. So, so I'm not sure that from the perspective of the person who's willing to abort, that there's any conflict. They want to know, and it's easy to know, and it is now easy to know without any risk to the child if it is the gender you prefer.
And then secondly, I was just wondering if any of you three, first of all, if you listen to On Being with Krista Tippett, and specifically if there's she invited 2 guests on her show, and I don't know the names of them, but it was in a podcast called Pro-Life, Pro-Choice, Pro-Dialogue. And it was like the 2 sides that were putting down the terms like pro-life and pro-choice, because they claimed on here that there are very few people who are like totally pro-life or totally pro-choice. And they're terms that don't really help in the discussion of how to find common ground in this. So I was wondering if you guys could speak to any common ground you've found and ways to connect and get to a solution for both people.
I have ideas. One of them is, you know, in part, I view these proposals for banning sex selection abortion as like, I think Professor Collett's phrase was the edge of the wedge, right? A way of forcing the conflict. But another way of putting it is, can we at least find common ground that there are some reasons for abortion we do not wish to tolerate? Can we reverse Roe versus Wade to that extent? And then once I have you there, I'll ask you about the next step. Right? Once we get there, but can we at least agree to this? And that actually is a common ground. Another common groundish type of proposal, I don't have a lot of optimism for it, is could we agree that our children should not abort their children? That we could ban abortion as of 40 years from now, or 30 years from now. And the idea being, can we commit to not continue, can we recognize it as, if it is a choice that that it is one that we only tolerate as a tragedy and we should be working to find technological ways not to continue to do? Now I have some trouble with that because it's like, it almost says like, let's have 30, 40 years of free fire zone for genocide, okay? But in principle, if you could agree with people to ban abortion at some time out in the future, would you at least take that? You know, I don't know. But otherwise, I'm afraid that the premises of the pro-life position, fundamentally, and the pro-choice position are at bottom just completely irreconcilable. Okay, and it all comes down to the question of, is this a living human person, a member of the human species with rights to life or not? And if you say yes, a lot follows from that. And if you say no, a lot follows from that. And they go in different directions. So it really it's like that's the fault line question is, what is abortion? What does it do? What is its moral nature? What is the moral status of the living human fetal being?
Professor Delahanty, you covered that in class today. What, do you have anything to add?
I think
Mike,
there is
please.
common ground, or could be.
Mike, please. Not this mic, that mic.
I think that there is or could be common ground. There was a wonderful colloquy, debate between 2 women at the law school within the last 12 months or so, one from Boston College, one from Notre Dame, discussing abortion from 2 different points of view, but with what seemed to me tremendous realism and seriousness. And they both agreed that the problem of having abortions is most likely to be found among poor women. Often they are already heavily burdened with having other children and with finding work and with keeping in some kind of balance their responsibilities to work and their responsibilities towards their children. One of the speakers said that deplorable situation for poor women is not going to change, and that for them, because the burden of having an extra child would be so severe, they should have access to abortion. The other speaker said, I think we have to change the situation for women so that if they want the extra child, they can afford the extra child. So I see common ground in social policy, not in law, but I think that there's some risk that we as lawyers might be framing the issues here too starkly, and that we should think perhaps about abortion more from the viewpoint of policymakers or politicians who really do look for common ground. A lot of our current abortion regime, maybe most of it, tilts in favor of men. This is why I find it somewhat puzzling that women who call themselves feminists should think that abortion has to be the pro-feminist position. It actually isn't. I think it is harmful, and I think studies bear this out in many ways to women, especially to the kind of women who want a lasting relationship with a man, who want marriage, who want love, who want intimacy, who want a family. Abortion makes sex cheaper, and it desensitizes men. It encourages men in their already deplorable tendency to run away from any child they fathered to think that sex should be pleasurable but consequence-free. It's actually not antagonistic in the least to feminism to try to change the incentives for men and to try to force them, or induce them at least, to bear full responsibility for the consequences of their sexual activity, including fathering children, parenting children who are theirs, providing for them, working for them, and modeling for them. So, in a nutshell, my answer is yes, there is common ground. We should seek for common ground. We should seek to make men more responsible for the children they bring into the world, but for abortions would bring into the world. We should have them share much more of the cost for women. We should not especially create a trap for poor women in which they think they have no choice but to abort. Partly this is a matter of social attitudes, partly of governmental intervention, but the cost of the additional children for poor women should be imposed to a much greater extent on the men who have brought those children into being, and then from the rest of society, which has the enjoyment and the benefit of having a lot of children. One of the things that's very wrong with our society, which is a pretty rotten society right now, if you ask me, is that there's not enough youth and vitality and children. And we would all of us, benefit from having much more of those things.
We get more students, too.
Yes, sir. Oh, I'm sorry.
So I noticed that one side was advocating largely the personhood of the child and the other the choice of the woman. And it seemed like a lot of times that both sides are shooting past each other. Like, do these arguments actually connect, or are they actually just shooting past each other, not actually engaging each other?
My experience in litigation is they don't actually engage each other. They actually are shooting past each other. And the United States Supreme Court has enlisted itself on one side. If I were actually, depending on the judge I was in front of, if I were, and I have, in defending abortion laws, if I know the predilection of the judge, I will or will not described that as the unborn child, because there is common ground to some degree with some judges about things like clinic regs. Why the other side wants to fight about whether or not doctors should have admitting privileges to hospitals within a 30-minute drive truly is beyond me. And they won. The state of Texas won that case in the Fifth Circuit just this past couple of weeks, in part because 15 years ago, the other side on their own website said one of the ways you pick a good abortion doctor, which may seem an anomaly to many of us in this room, but nonetheless, one of the ways you do that is you find a doctor who has admitting privileges, so if something goes wrong, they can get you to the to the hospital and can actually take care of you there. And because we have so far talked across each other, that they're beginning to take positions that are contrary to the well-being of women, as we saw in Philadelphia with Dr. Gosnell. That you have there a Republican governor who says that we're not going to inspect these clinics, even though we'd inspect other dental offices, et cetera, other regulated providers. We're not going to inspect them because that might discourage women. And so Gosnell engaged in his conduct for decades. So we really are talking past each other. Part of it's distrust, a terror that nobody's motivations are real anymore, and so what logic would tell us can't be right. Part of it is the other side for a long time thought they'd won, thought we'd go away, because the reality is political battles are won by those who slog it out and stay with it. The abolitionists started from the founding of this country, and it took them till 1865. You know, you got to be the last woman standing or the last man standing if you're going to win. And that's one of the achievements of our side, is not only are we the last man and woman standing, we're the younger generation. You know, I believe it'll happen.
You guys. let me just add something to that. I think you're right that in legal argument, really, it's like how you frame the issue means everything, and it does mean each side frames its position a certain way and tries to get the audience, the judge, whoever it is, the public, to see the issue in those terms, right? And the pro-choice, quote unquote, position, well, even that, you know, is an advertising label. That's good advertising. Anybody here against choice? Anybody here against freedom? Okay. And the pro-life position, again, that's an advertising stance. It's a characterization stance. When I was arguing this side, look how I started off. This is a case about privacy and freedom of choice. Oh, if you buy my characterization of it, I've got you, right? Because then it can push away everything else. If I start at if the starting point though is, like when I give my own talks, I like to say, abortion is, I mean, let's be clear about what abortion is. It is the killing of a life, right? I mean, there is an existing discrete life. It is a human life. It is the same human life that it will be at later stages. Abortion kills a human life. Can we start there? And if I start there, a different sort of set of considerations forward. And I think each side tends to do that. Once Professor Collett had to be away and we were doing this debate for law students, and at the last minute we had to fill in. We were trying to decide if Professor Delahunty would argue her position or he'd still be the judge. And so at the last minute we decided I would argue both sides. And so I stood up. This is fun for me. I have two of my former students here who know how I like to play, right? And I got up and the pro-life side argued that this characterization, and I sat down and actually did a 360 and got back up and stood up. And started with, this is a case about privacy and freedom of choice and about who gets to make the decision. And the law students just laughed, kind of in delight. It's like, oh, we see now how you can argue out of two sides of your mouth, right? But that's kind of what's going on, is that people are starting from different premises, frame the issue entirely in their terms, and want to talk past the other side. the pro-choice position very badly wants to talk past the nature of what abortion is. So if you're a pro-lifer, don't let it. Say, whoa, wait, let's start here. What is abortion? Choice to do what? Can we be clear on that? Choice to, what is abortion? What does abortion do? What is abortion? Okay. So frame the debate on your terms.
One of the other issues that I think really makes it clear is, I think the fundamental question, is abortion the right to kill, or is it the right to be free of an unwanted pregnancy? Okay, right? The phrase is terminate an unwanted pregnancy, but let's just say be free of, because I'm going to give them more language. Okay. The frozen embryo cases in this country, and Professor Paulson knows, and I tried to get the United States Supreme Court to take a case out of Texas that I was appellate counsel in. Here's the fundamental state of the law. If a man and a woman uses assisted reproductive technology to create what I believe are, and what the nation of Costa Rica believes, are tiny developing human beings. They are members of Homo sapiens, according to even our 8th Circuit. These are unique, separate members of Homo sapien. So if that's true, then the question is, what happens to all of these tiny little frozen beings? And every court in this country where the couple who have created these frozen embryos get into a fight, every court in this country has ordered either the destruction of the embryos or that they stay in a suspended state, period. Not once, whether it's a woman or a man, who contributed either the egg or the sperm, who want to continue the development of those tiny little frozen creatures, have they won in court? Not once. The case I was involved in, the woman was no longer capable of conceiving a child because of her age. The case in France that we lost in the European court involved a woman who, because of cancer and radiation, was no longer capable of conceiving a child. The man in both those cases consented to the creation of the embryos. This is not the sleeping prince who was deprived of his sperm, consented to the creation of those embryos, but changed their mind and argued that they were not psychologically ready to be fathers. Every case in this country, the embryos have been destroyed or left permanently in the freezer. Now, the reason I think this is an important case, similar to the sex selection, is because there, no one is engaged in a, quote, forced pregnancy, to use the phrase of the other side. Right? These are women who want the implantation of their biological children. These are men who have women who are willing to bring their biological children to term. Every case, those embryos have been destroyed or retained. Now, if the right to abortion is the right to kill, those cases make perfect sense. Right? They make perfect sense. If it's simply to be free of an unwanted pregnancy, the people who are genetically related to these embryos who want to continue their development should prevail, because there is no burden on the other side other than the psychological burden of having participated. The United States Supreme Court's not willing to take that case yet, but when they do, I think we will have some clarity on this question of whether the right to abortion is a right to kill, which the court has told us time and time again it's not, but rather necessity, because women need to be free of pregnancies they do not want to undergo. It'll be an interesting case.
Can I argue with you for real?
Absolutely.
Okay.
And then, yeah.
I worry about these cases. Let me just
I know.
muse
I
out
worry
loud.
about them
I
too, 'cause we
worry
keep
about
losing.
it Because I think it's often people's intuition that the sort of conceived test tube embryo, well, that's not a person, right? When you can see the picture at 133 days, people's intuition is, oh yeah, it really is a baby. But I mean, logically, if you're Mr. Spock or Lieutenant Commander Data, it is the same human life form at each stage, right? But people don't think with their logic, they think with their intuitions and their guts. I think most people's intuition is, well, a non-implanted test tube generated, that's not anything. And my concern would be actually it's interesting as I hear you describe these kids, because I don't know these cases well. Even your description says, well, one of the parent wants that biological child. It's like, creates the idea that there's an ownership interest of the parents in the embryo, and the parents could get to choose whether to own up or
Kind of
not.
like women and abortion?
Well, yes, exactly. Exactly. And I think, I wonder if anyone has given thought to the idea that unwanted discarded embryos should have their own autonomous rights and their own people who would speak for them. In other words, that if
Guardian
someone,
ad litem.
well, right, if the biological contributors, let's say, that's not quite parents.
Progenitors.
If the progenitors disclaim an interest, they're out of here. They're done. And then the question is whether, can someone speak for the life of the created being? My other concern is that so many people now have engaged in various forms of assisted reproductive medicine, right, or technology, and it often does involve the collateral destruction of embryos. That I think people are desensitized to it, right? The idea that, my baby that was born through this reproductive technology would not have existed if we couldn't have discarded 8 or 10 of them. I think it becomes a really strong cognitive dissonance for people to be able to think in those terms. Reaction?
In Costa Rica, the Costa Rican Constitution says that human life begins at conception. And because of that, when the national legislature passed a bill allowing IVF, the Costa Rican Supreme Court said, no, that violates the right to life, because 90% of all those embryos that are created are in fact destroyed. They die. And they therefore found, as a matter of their national constitutional law, that couples who were having fertility problems should use what's called nanopro technology. The court didn't specifically identify that, but said there are other methods. And according to various peer-reviewed medical journals, in fact, Dr. Hilgers and Dr. Stanford were just over at the University of Minnesota this week presenting a lecture on this. They have a comparable birth rate if you use these other procedures. The International Court, the Inter-American Court on Human Rights came in and told Costa Rica their law violated international treaty because they believe that people have a right to create these embryos. And so it seems to me that if we are concerned about human life at the moment of fertilization, and that's why you hear me use the phrase fertilization rather than conception, in the medical text they now are redefining conception to mean implantation. And the reason is because you've got these non-corporeal embryos. So you've created this, you've fertilized, you've created this new Homo sapien, but nobody's pregnant. So pregnancy doesn't begin in those instances at fertilization. It begins at implantation. There are certain nations that do not allow the freezing of embryos, period. So any use of IVF requires implantation prior to the expiration of the embryos because they believe that it's destructive of human life. And so every embryo that is brought into being in the lab must be given the chance of birth by implantation. So they limit the creation of embryos either by number or they make illegal the freezing of them. Now that's not to get us off topic, because I know you asked us to come and talk about Roe, but I think we need to think about all of this. There's an article by Larry Tribe, who's a major pro-choice professor at the university at Harvard, where he said, when we create the artificial womb, that will pose a real problem to the pro-choice mentality. When we get to the point where a woman who has an unwanted pregnancy can go in and in an in-office 1-hour procedure, we can extract that embryo and we can place it in an artificial womb so that she can be free of the pregnancy, will she still have the right to say no? I want that embryo killed, especially over the objection of the father. And so I'm still optimistic, but everybody's strategy is different. So should we take one or two more?
Can I ask a question of the audience? It's about one of the arguments I made that was a flat-out lie. And I'm wondering if you were persuaded by it. The argument that precedent, because the Supreme Court has decided the case one way, should have a binding effect on future decisions, and that the Supreme Court's decisions have to be binding on all other actors within our society. What do you think of that? Oh, I know what Caitlin thinks, and Rachel too.
How could we ever create new laws if we never redefine the old ones? Or, like, how can we create anything new if all we adhere to is the old? Does that answer your question?
So you don't find it persuasive?
No.
When the Supreme Court says something, should it stick with it?
I can't give a good reason, but I guess my gut says no.
Other reactions on that?
What comes to my mind is the Constitution and constitutional amendments, being is that the Constitution was created at a certain point in time with the possibility of, in the future, amending it, and which has been done even with, I think it was the Prohibition Amendment, the two amendments, one amendment which outlawed alcoholic beverages, or I can't remember the sale of it, and production of it, and then the amendment which just a few years later undid that amendment.
Well, that's a little different situation. I mean, you can amend the Constitution, but if the Supreme Court has interpreted the Constitution, interpreted the text you have one way, should they stick with it for purposes of consistency, stability, people rely on its interpretation? What do you think of that? It has a lot of traction in the legal community. People say, oh, precedent, stare decisis, but do you buy it?
No, like I think that if the Supreme Court rules in one direction and makes a decision, and later revisits it and finds that there was an error or in their judgment or some other evidence and a new argument was brought to light, and they believed that the decision that was made was not within the reason of the Constitution that is like the founding of our country, then they shouldn't stay with their decision just because it's consistent. Because I guess like the United States is founded on change and like challenging different laws. And so when you have that, and if we would have stayed with consistency, we wouldn't have had even the United States. And I think that's important to like know, is that we have to make those changes that are necessary for the betterment of people.
Can I come back at you? This is what law professors do. We do a Socratic method and back and forth. If the Supreme Court decides something you think is wrong, and you're president or Congress, okay? The Supreme Court has misinterpreted the Constitution. Do they get to decide, or can you work to resist the Supreme Court's decision? What do you think? Gentleman back there. You, yeah, that's right. Don't turn around.
Impossible. Can Congress say that that they misinterpreted? That was my question. Okay, just making sure. So I have a clear understanding of.
This is how Lincoln actually rose to power.
or prominence is by taking the position that the Supreme Court's decision in Dred Scott was wrong, should be reversed, and should be resisted in its extension to other situations. And it's sort of, but it's controversial. It's controversial, right? Because the other side is, well, don't want politicians just ignoring Supreme Court decisions that they disagree with. But I wonder, whose Constitution is it?
Do you think that the Supreme Court is always? Do you believe that the Supreme Court can make? I need to phrase. I need to think over that question. I have an idea of what I can say, but I don't know how to phrase it. So maybe if you could come back to me. I don't think we can come back to me, but we don't have time. But my friend here.
One last question before
The very last one.
The very last question.
Oh, from the audience as opposed to you.
Yes.
Good.
Oh, yes.
This poor young lady has been
she's been
patiently
passed over.
waiting. Yes.
Give her the mic.
I actually, from the very start of this debate, the one thing that's been gnawing at me the entire time is I kind of want to understand better the strategy involved with even trying to ban something like the sex selection abortion, or any reason that any woman wants an abortion. Could you explain maybe why that could be a good strategy, bad strategy, when to me, it almost kind of distracts from the ultimate question. And I think one of you touched on this earlier with, what abortion is, how it's defined, what a human person is, and how that's defined. All these different strategies of trying to make laws to restrict abortions, maybe explain why that might be good strategy or bad strategy. Because it doesn't sit well with me at all, to be honest.
Can I jump on this? Okay.
Uh-huh.
Okay, imagine a dialogue, okay, with someone whose position is pro-choice or hasn't thought it through. And if you start, what do you think of sex selection abortion? They say, no, that's terrible. That's a bad idea. That's like hostile. Okay. Say, why? Well, that discriminates against women. What makes this a woman? Well, the fetus or embryo has a sex? Yes. Oh. You're starting to think about, well, what is this thing? Right? The whole idea of banning sex selection abortion is an attack on the itness of the fetus. It's a way of, it's sort of a foot in the door to the idea of the basic human quality of the fetus. What makes it wrong to abort a fetus on the basis of its sex is that the fetus is a person, right? And at some point, at least this is my motivation, there's the aha moment when people say, no, well, wait, if it's wrong to abort the girl because she's a girl, isn't it wrong to abort the girl anyway? It's a person. Huh. Right? So part of the idea is, it is a way into people's minds to sort of dislodge the construct that has been created by the pro-choice position that the human fetus is just a mass of indiscriminate tissue. It's like, if it is a girl or a boy, that colors the whole way you see the issue, I think. So I think it's really persuasive way of getting into people's hearts and minds, which is my motivation for it.
I suspect that your question suggests that the right way to do this is to pass a human life amendment. That we need a national constitutional amendment that says, like Costa Rica, life begins, I would prefer at fertilization, but I'll settle for conception. Life begins at conception, and the law will afford full protection of every human being from the moment of conception. We have tried, and frankly, those efforts have sort of fallen on deaf ears. Doesn't mean we shouldn't continue to try, And we see states making those efforts at the individual basis to bring it before the United States Supreme Court. But in the interim, we really do have to reclaim the hearts and minds, not only of the general public, but right now, it's the legal elite who control the issue. It is the United States Supreme Court that initially said partial birth abortion was just fine. And it wasn't until we persuaded our Congress to ask them to rethink it, well, actually to tell them to rethink it, that we were successful in getting that horrific practice banned. So I think we need all of these efforts. And I get a little frustrated that our side seems to lack a unity and charity toward each other that we show toward the other side with the strategies. So I would like to thank Students for Life on main campus. We are very grateful. You really are the old fogey's hope that we will see this change. I would also like to thank those of you who are pro-choice, and I don't know who you are beyond the self-admitted heretic in the room. But actually, I think that's the best tradition of the university. And it's certainly what we try to teach at the law school. If you don't know and understand the other side, you're not ready to argue. So those of you who are pro-choice who gave us your evening, thank you, whoever you are. We're very grateful to have you here, but most importantly, we're grateful for Students for Life allowing us to present tonight. Thank you.
Let's thank, of course, our presenters, Professor Collett, Paulson, and Della Hunter.